Your Honors, the matter before the court this morning is the case entitled In Re Allison McCarthy, case number 25 AP 106. Representing Office of Disciplinary Counsel is Attorney John Alexander. Respondent Allison McCarthy is not present.
Thank you very much, and good morning, everybody. Good morning, counsel. We'll hear from you first, obviously. If you would, for the record, introduce yourself, identify your client, and then proceed.
Good morning. This is John Alexander, Disciplinary Counsel, appearing for the Office of Disciplinary Counsel. And we're here this morning on my office's petition for interim suspension of the respondent, Allison McCarthy. And specifically, the petition arises out of the respondent's refusal for the past several months to provide a written response to a client's professional misconduct complaint against her. And in addition, the respondent has not communicated at all with disciplinary counsel for at least 2 months now. And this fits the criteria for interim suspension under AO9 Rule 22 because the refusal to respond to disciplinary counsel's lawful request for information is a violation of Rule of Professional Conduct 8.1b, and that refusal to cooperate in itself presents a present threat of serious harm to the public, and that warrants immediate interim suspension.
Mr. Alexander, any issue involving her request for to her insurance carrier for indemnity and defense to both this and the claim by the person who filed the complaint?
Well, I'm not fully apprised of the details of her communication with her malpractice carrier. I can only surmise that she made a request to her malpractice carrier for defense. Obviously, there's no indemnification in an attorney misconduct matter, but I gather she was seeking to have her carrier either appoint and pay for defense counsel or agree to reimburse her defense costs. And that's the extent of what I know. And really, it's not relevant to her duty to cooperate with disciplinary counsel. She can retain counsel if she wants, but she has to do that in a relatively timely manner so that the investigation is not impeded. And at the end of the day, she still has an independent duty to cooperate and communicate with me.
The only reason I asked is that the carrier might be concerned about how she responds that would jeopardize its position, but you haven't heard from anybody, period.
I have not, Your Honor. I have not heard from Respondent McCarthy or any attorney purporting to act on her behalf.
Thank
you. So I think perhaps the main issue that might warrant further analysis by the court is really what the court just alluded to, which is that I'm obviously speculating, but Attorney McCarthy may ultimately claim that she was prevented or delayed in responding to my inquiries because she was seeking counsel. And as I've set forth in the petition, there's ample authority from other jurisdictions holding that an attorney may have counsel, but is not constitutionally entitled to that counsel, and they're certainly not constitutionally entitled to have as much time as they need to find counsel and have that counsel prepare, because there is that independent duty to cooperate with disciplinary counsel and their request for information. Beyond that, the request here is certainly consistent with this court's prior decisions on interim suspension, in the sense that those prior decisions, probably the most apt one is the In Re Tao decision from about 3 years ago, held that refusal or failure of an attorney to respond to disciplinary counsel's lawful request for information in itself is a present and substantial threat of serious harm to the public interest. And as set forth in greater detail in some of the authorities cited from New York, that failure to respond and cooperate in itself undermines the whole functioning of the attorney disciplinary system, which threatens the public and therefore warrants interim suspension. So I think that based on those authorities and the court's prior decisions, immediate interim suspension is well warranted here. And frankly, I've sort of run out of options to make contact with the respondent other than perhaps hiring an investigator and trying to find her physical whereabouts. Beyond that, there's really not much more I can do. And I guess the hope is that when she hopefully does receive this notice of interim suspension that I'm requesting, that might induce her to begin cooperating with the disciplinary investigation again.
Counsel, have you prepared a draft order?
I have, and I have filed that with the court.
All right, thank you.
So I can answer any further questions the court might have, but I think the grounds for the interim suspension are set forth in the memo, but I would be pleased to answer any other questions. Beyond that, I have really nothing further.
Okay, I don't see any hands. So if there's nothing further, we'll call the conclusion of the hearing. Please go ahead and conclude the hearing.
That concludes today's hearings.